first topic, let's talk about managing ethical risk through mandated voluntary programs. Voluntary practices are the beliefs, the values, and voluntary obligations that an organization put into practice. Like all business, commit to voluntary practices or programs because it benefits both internal and external stakeholders. It was like using the advantage for the good of their companies. The laws, regulations, and rules are the mandatory programs that are imposed by the state and the federal government, or let's say was established by the government, which a very big help in setting the behavior of people. There are laws that regulates the business in place, laws which are out in place to regulate the competition within business, laws which have illegalized monopolization of businesses, and also laws that protect the consumers. As a whole, it is to keep all the people at a fair level of treatment.
The Philippine Competition Law, or the RA 10667. The Philippine Competition Act, or the PCA, or better known as the RA 10667, is the primary competition policy of the Philippines for promoting and protecting competitive market. It will protect the well-being of consumers and preserve the efficiency of competition in the marketplace. The PCA was passed in 2015 after languishing in Congress for 24 years. It is a game-changing legislation that is expected to improve consumer protection and help accelerate investment and job creation in the country, consistent with the national government's goal of creating more inclusive economic growth. Enforcement of this law will help ensure that markets are open and free, challenging anti-competitive business practices while maintaining an environment where businesses can compete based on the quality of their work. A competitive market means a market with multiple buyers and multiple sellers, driving market prices lower and offer consumers more choices. A truly competitive market encourages efficiency and innovation and forces businesses to excel. The acts reflect the belief that competition promotes entrepreneurial spirit, encourages private investments, facilitates technology development and transfer, and enhances resource productivity.
This is Cherny Cañada, and I'm going to be talking about the topic of the laws protecting the consumers. Here in the Philippines, we have this Republic Act 7394, or the Consumer Act of the Philippines, that was established during 1992. It is the policy of the state to protect the interest of the consumer, promote his general welfare, and to establish standards of conduct for business and industry. So here are the aims to achieve in these laws: protection against hazards to health and safety, protection against deceptive, unfair, and unconscionable sales acts and practices, provision of information and education to facilitate sound choice and the proper exercise of rights by the consumer, provision of adequate rights and means of redress, and involvement of consumer representatives in the formulation of social and economic policies. Here we have the 8 rights of the consumers. It is the right to basic needs, the right to safety, right to information, right to choose, right to representation, right to redress, right to consumer education, and right to a healthy environment. So let's go to the implementing agencies. These are the agencies involved in implementing these laws. The first we have the Department of Health, Department of Agriculture, Department of Trade and Industry, DepEd or Department of Education, Bangko Sentral ng Pilipinas or BSP, and Security Exchange Commission, which is the SEC. So first categorization is we have about the food, which is under Article 23, which relates to adulterated food or those foods that are being processed with ingredients that are prohibited or banned products so that this food will be in good quality. Thus, the food is deceptive in itself. So Article 24, Regulations of Unprocessed Food. So under this Article 24, it has stated there the regulations of the unprocessed food. And let's go to drugs. We have Article 29, Adulterated Drugs and Devices. Article 32, Dangerous Drugs, which are being prohibited. Article 33, Banned or Restricted Drugs that are being circulated. Article 40, Selling any drugs beyond its expiration or expiry date. And we have the cosmetics under Article 35, adulterated cosmetics. These are the prohibited ingredients or cosmetics in itself, which have the ingredients, which has the unnecessary ingredients for the cosmetic to be in volume in better quality, but it is prohibited. Article 46, receiving any mislabeled hazardous substance or banned hazardous. Article 50, deceptive act or practice by a seller or supplier in connection with a consumer transaction. So, Article 62, sealing and testing instruments of weights and measurements. So under this, all instruments for determining weights and measures in all consumer-related transactions shall be tested, calibrated, and sealed every 6 months by the official sealer. Article 64. Imitating any characteristic sign used to indicate that such instrument of weight or measures has been officially tested, calibrated, sealed, or inspected. So it must be inspected, calibrated, and sealed. Article 81. Offering any consumer products for retail sale to the public without an appropriate price tag, label, or making publicly displayed to indicate the practice of each article. Article 68, Terms of Express of Warranty. So in this article, this is about the warranty of the consumer products. So it shall be stated there, it must be stated there that the seller or the manufacturers will identify the party of whom the warranty extended, state the product or parts covered of warranty, what the warrantor will do if defect, and what the consumer must do to avail new product or replacement. Now let's go to labeling and fair packaging of Chapter 6 of Republic Act 7394. Here in Article 77, because we have there, it is there is a right for a consumer uh, to know the processing of the product. So here in Article 77, minimum labeling requirements for consumer products. So the product must have registered trademark or brand name, duly business name, address of the manufacturer, importer, repacker, general or active ingredients, not quality of contents, and country of manufacturer. And in Article 78, this is about the Philippine Product and Standard Mark. Article 80, the special packaging of consumer products for the protection of children. So, the, if the product is not for children, it must have a label that this product is not for children. Article 84, additional labeling requirements for food. Example is the expiration date, if the product is semi-cooked, fully processed or not cooked, or natural or synthetic. Article 87, additional labeling requirements for cosmetics. And in Article 94, labeling requirements for cigarettes. So first, let's know what is consumer product or service. A consumer product or service means goods, service, and credits, debts or obligations which are primarily for personal, family, household, or agricultural purpose, which shall include but not limited to food, drugs, cosmetics, and devices that I have been said a while ago. So, when is the Consumer Act applicable? It has been said there that the act is applicable if the complainant is a natural person. The subject of the violation is a consumer product or service, because if it's not a consumer product or service, then the Consumer Act is not applicable to what you are being complaining about. Then the last one is the nature of the complaint is regarding any of the aforementioned concern. So what I have mentioned there, the complaint is must be about them. Next is what should a consumer do if he or she has a complaint? Number one is identify the problem. So if there is no problem, there is no complaint. And the complainant must um, give or create a settlement, the one who is being complained, if it is refund, repair, or replace. Then the complainant must gather documentation for it to be valid, for the complaint to be legit, like receipts, warranties, repair orders, contract or agreement, or concealed checks, or any document which will support the complaint. Next one is go back to the store or office where you made the purchase. And the last one, if you are not satisfied with the support, write a formal letter of complaint to the concerned government consumer protection agencies in the Philippines mentioned above. So the implementing agencies that I have discussed a while ago, you can complain to them with a formal letter with your name and address and what you're complaining about, the place, and of course the date and the supporting document. How long can a consumer file a complaint? Within 2 years, starting from the time the consumer transaction happened, when the deceptive or unfair transaction took place. So, within 2 years. To whom does a consumer file a complaint? In the provincial office, the administrative complaint shall be filed in duplicate with the provincial office having jurisdiction over the subject of the complaint. In areas where there are no provincial office, the complaint shall be filed in the regional office. In cases where the complainant and respondent are situated in different provinces, the complainant has the option to choose the place where to file the complaint. So what are the remedies available to consumers? Number one is for administrative proceedings. There is a replacement or a reimbursement or a refund of payment made or a restitution or rescission of contract. But for civil or criminal action, there is a civil action for that. or a refund of payment made, award of damages, restitution or rescission of contract, replacement or repair of products, reimbursement, and criminal action, which is the defendant, if found guilty by the court, shall be sentenced to imprisonment, payment of fine, or both at the discretion of the court. How are consumer complaints resolved? It will be resolved of the implementing agencies that I have mentioned above if the complainant has filed a complaint. But if no amicable settlement is arrived at, the complaint will be scheduled for preliminary conference for the parties to enter into a stipulation of facts or arrive at simplification of issues. Then formal hearing will be conducted by the arbitration office. Decision of the arbitration officer is appealable to the secretary of the concerned department within 15 days from receipt of the decision. Then the decision of the department secretary um, within 50 days, or the Supreme Court of the following grounds: there is a grave abuse of discretion, the decision rendered was in excess of jurisdiction or authority of arbitration officer, the decision is not supported by evidence, or there is serious error in finding of facts, and the administrative penalties that can be imposed. So these here are the penalties in the issuance of this of cease and desist order, provided however that such order shall specify the acts that respondent shall cease and desist from, and shall require him to submit a report of compliance therewith within a reasonable time. The acceptance of voluntary assurance of compliance or discontinuance from the respondent, which may include any or all of the following terms and conditions: an assurance to comply with the provisions of this Act and its implementing rules and regulations; an assurance to refrain from engaging in unlawful acts and practices or unethical trade and practices subjected of the formal investigation; an assurance to comply with the terms and conditions specified in the consumer transaction subject of the complaint; an assurance to recall, replace, repair, or refund the money; an assurance to reimburse the complaint; restitution or rescission of the contract without damages; condemnation and seizure of the consumer product found to be hazardous to health and safety; and the last one is the imposition of administrative fines in such amount as deemed reasonable by the Secretary, which shall in no case be less than 500,000 pesos. Oh, 500 pesos, nor more than 300,000 pesos, depending on the gravity of the offense, and an additional fine of not more than 1,000 pesos for each day of continuing validation. So this is the law protecting consumers in the Philippines, which is specifically the Republic Act 7394, or the Consumer Act of the Philippines.
The OSH law, or the RA 11058, reinforcing occupational safety and health standards in the Philippine workplaces through RA 11058. Safe work procedures ensure better productivity as well as job security, and these are needed now more than ever in the midst of the coronavirus disease 2019 or the COVID-19 pandemic. The health and safety of workers in the Philippines are promoted and protected by Republic Act number 11058, or an act strengthening compliance with occupational safety and health, or OSH standards, and providing penalties for violations thereof. It was signed into law by President Rodrigo Duterte in August 2018. The Department of Labor and Employment, or DOLE, released the implementing rules and regulations, or the IRR, in December 2018 upon the approval of Labor Secretary Silvestre H. Bello III. The OSH law provides that each Filipino worker is protected against injury, sickness, or death through safe and healthful working conditions, and that employers must promote strict but dynamic, inclusive, and gender sensitive measures in the formulation and implementation of policies and programs related to occupational safety and health. It applies to all establishments, projects, sites, including Philippine Economic Zone Authority or the PEZA establishments, and all other workplaces. The exposure to safety and health hazards is the basis for having high risk establishments, medium risk establishments, and low risk establishments. All covered workplaces must have an occupational safety health or the OSH program that is approved by the DOLE. The OSH program must have the following: A. Statement of commitment to comply with OSH requirements. B. General safety and health, including a drug-free workplace. C. Human immunodeficiency virus or the HIV and acquired immunodeficiency virus syndrome like AIDS, tuberculosis, or hepatitis prevention control. D. Company or project details. E. Composition and duties of the Safety and Health Committee. F. Occupational safety and health personnel and facilities. G. Safety and health promotion, training, and education. H. Conduct of toolbox meetings. I. Accident or incident or illness investigation, recording and reporting. J. Provision and use of personal protective equipment or PPE. K. Provision of safety signage. L. Dust control and management and regulations on activities such as building of temporary structures and lifting and operation of electrical, mechanical, communication systems and other equipments. M. Provision of workers' welfare facilities. N. Emergency preparedness and response plan. O. Waste management system. And B. Prohibited acts and penalties for violations. Each workplace must have an OSH committee to oversee the overall management of the OSH program. An OSH officer must be present in a workplace at all times to ensure the enforcement of the OSH program. The DOLE requires all safety and health personnel to undergo mandatory training on basic OSH for safety officers. It also requires all workers to undergo the mandatory 8-hour safety and health seminar that must have a joint employer-employee orientation. Meanwhile, the OSH law outlines the duties of employers, contractors, subcontractors, and those who manage, control, or supervise work. So, one is furnish the workers a place of employment free from hazardous conditions that are causing or are likely to cause death, illness, or physical harm to the workers. 2. Give complete job safety instructions or orientation to all the workers, especially to those entering the job for the first time, including those relating to familiarization with their work environment. 3. Inform the workers of the hazards associated with their work health risks involved to which they are exposed to. Preventive measures to eliminate or minimize the risks and steps to be taken in cases of emergency. 4. Use only approved devices and equipment for the workplace. 5. Comply with OSH standards including training, medical examination, and where necessary, provision of protective and safety devices such as personal protective equipment or PPE and machine guards. 6. Allow workers and their safety and health representatives to participate actively in the process of organizing, planning, implementing, and evaluating the safety and health program to improve safety and health in the workplace. And 7. provide where necessary for measures to deal with emergencies and accidents, including first aid arrangements. Workers also have duties such as following the OSH standards, using the PPE and other safety devices, and reporting work hazards to the supervisor. The following rights of workers are indicated in the OSH law. 1 is the worker's right to know. 2 is the worker's right to refuse unsafe work. And 3 is the worker's right to report accidents. So 1, the worker's right to know. The right to safety and health at work shall be guaranteed. All workers shall be appropriately informed by the employer about all types of hazards in the workplace and provided access to training and education on chemical safety, electrical safety, mechanical safety, and ergonomical safety. Number 2, the worker's right to refuse unsafe work. The worker has the right of refusal to work without threat or reprisal from the employer if, as determined by the DOLE, an imminent danger situation exists in the workplace that may result in illness, injury, or death, and corrective actions to eliminate the danger have not been undertaken by the employer. Last is 3. Workers' right to report accidents. Workers and their representatives shall have the right to report accidents, dangerous occurrence, and hazards to the employer, to the DOLE, and other concerned government agencies exercising jurisdiction as a competent authority in the specific industry of economic activity. Last is number 4. The workers' right to personal protective equipment, or the PPE. Every employer, contractor, or subcontractor, if any, shall provide his workers free of charge protective equipment for their eyes, face, hands, and feet, and free and lifeline safety belt or harness, gas or dust respirators or masks, protective shields whenever necessary by reason of the hazardous work process or environment. The Labor Secretary and his authorized representatives have the authority to enforce the OSH law in all establishments and conduct inspections, investigations, and annual spot audits.
Law protecting environment. Republic Act 1903, Ecological Solid Waste Management Act of 2000. This law aims to adopt a systematic, comprehensive the ecological solid waste management program that shall ensure the protection of the public health, the environmental, ensure the proper segregation, collection, storage, treatment, and disposal solid waste, to the information and adoption of the best eco-waste product. Republic Act 9275, Philippines Clean Water Act of 2004. This law aims the project of the country water bodies for population from the land-based source. It provides the comprehensive and integrative strategy to minimize the population to the multi-sectoral or and participatory approach involving all stakeholders. Republic Act 8749, Philippines Clean Air Act of 1999. This law aims to achieve maintain clean air and meets the national air quality guideline values for criteria pollutants throughout the Philippines while minimizing the possible associated impact of the economy. Republic Act 6969, Toxic Substance Hazardous and Nuclear Waste Control Act of 1990. This law aims to regulate receipt of prohibit an important manufacture processing cells. Distribution use the disposal of chemical substances and make sure the present uninsurable risk to human health. It likewise the prohibits to entire event or transit of hazardous and nuclear waste and their disposal of the Philippines in territorial limits. Whatever purpose is to provide advanced advancement and facilitate research and studies on toxic chemicals. Presidential Decree of 1586 Environmental Impact Statement or EIS Statement of 1978. The environmental impact of assessment system was informally established in 1978 with the enactment of Presidential Decree number 1586 to facilitate the intendment of maintenance of rational and order the balance between socio-economic development and environmental protection or EIA. Is the planning and management tool will help government decision makes the proponents and affected economy address the negative consequence or risk on the environment. The process assure experimentation and environmental or environment friendly project.
Have a blessed day to each and everyone. I am Lynn Incaliat, Bachelor of Secondary Education, major in Filipino. We are the Group 4. We are assigned to report about the topic, the institutionalization of business ethics. And my leader was assigned me to report about gatekeepers and stakeholders. All organizations, especially financial in nature, must be governed with proper management in order to continue existing progressively. Like any other organization here in the Philippines, there are specific agencies that govern them in order to secure and verify whether they still operate in accordance with the existing laws. In particular, the SEC, or Securities and Exchange Commissions, as one of the regulatory agency that sees to it that any business who is brought into public will qualify the existing regulatory laws. Despite they appear to be a stock or a non-stock corporation, at least once a year, all these corporations should submit to their particular head offices. One of the most important documents, which is the GIS, or the General Information Sheet. Another document accompanying this is the AFS, or the Audited Financial Statement, that describes the financial standing of the corporation. It is noted that the General Information Sheet is certified by a practicing lawyer in order to be a notarized public document. On the other hand, the audited financial statement must pass the certification of a CPA or a certified public accountant who is accredited by the government, which is BIR or Bureau of Internal Revenue. These gatekeepers see to it that the information revenue are true and also correct. Upon them, the people of the Republic depends if they are presenting certifying an authentic document or not. Another regulating agency is the BIR, or the Bureau of Internal Revenue, which see to it that all corporations are complying taxation laws. They work hand in hand to see to it that dishonesty will be avoided in all documents. If this various code of conduct, ethics are defied, corruption will set in and it will lead to the downfall of many financial institutions. Corruption will paralyze the economy and the government. So that's all. I hope you learned something today. May God bless and stay safe, everyone.
What is Sarbanes-Oxley Act of 2002? The Sarbanes-Oxley Act of 2002 is a law the U.S. Congress passed on July 30 of that year to help protect investors from fraudulent financial reporting by corporations. Also known as the SOX Act of 2002 and the Corporate Responsibility Act of 2002. It mandated strict reforms to existing securities regulations and imposed tough new penalties on lawbreakers. The Sarbanes-Oxley Act of 2002 came in response to financial scandals in the early 2000s involving publicly traded companies such as Enron Corporation, Tyco International plc, and WorldCom. The high-profile frauds shook investors' confidence in the trustworthiness of corporate financial statements and led many to demand an overhaul of decades-old regulatory standards. Let's proceed. What is the next company? What is the Public Company Accounting Oversight Board, or PCAOB? The Public Company Accounting Board Oversight Board is a nonprofit organization that regulates auditors of publicly traded companies. The purpose of PCAOB is to minimize audit risk. The Public Company Accounting Oversight Board, or PCAOB, was established with the passage of the Sarbanes-Oxley Act of 2002. The act was passed in response to various accounting scandals of the late 1990s. The board protects investors and other stakeholders of the public companies by ensuring that the auditor of a company's financial statements has followed a set of strict guidelines. PCAOB is overseen by the Securities and Exchange Commission, and since 2010, the PCAOB has overseen the audits of SEC-registered brokers and dealers.
Communications between the audit committee and independent auditor. Independent Standard Board Standard Number 1 requires that the auditor disclose the audit committee in writing relationship between the audit firm and the company that may reasonably be thought to bear an audit firm's independence. Standard Number 1 also requires the auditor to confirm and discuss its independence with the audit committee. The audit committee should consider discussing the following issue with the auditor in regards to firm's independence disclosure. Processes the audit firms uses to ensure complete disclosure of all relationships with the company and its affiliates. Relationship, the audit firm may have officers, board members, and significant shareholder. Relationships not included in communication because they were deemed immaterial. Change of independent auditors. The auditor generally must be independent for the entire engagement period and the period covered by financial statements being audited. Once this relationship is terminated, there is no continuing requirement for the auditor to remain independent. The auditor may generally reissue its former opinions on the company's financial statements. However, if a restatement of financial statements become necessary, the auditor must be independent to order the restatement, adjustment, and reissue its opinion. Further, if the board is contemplating or plans a change in auditors, the audit committee must consider whether the prospective firm will be independent during the audit engagement period. That is, the prospective firm must cease all prohibited services and/or sever all prohibited relationship with the issuer prior to the beginning of the audit engagement period. Therefore, the audit committee should consider these issues before hiring a predecessor auditor or a prospective auditor to provide non-audit services to the company or its affiliates. Prospective firms cannot audit financial statements of the years that they were not independent, addressing independence issues. The audit committee should discuss and thoroughly investigate any potential independence, impairment, or issues. The audit committee should also consider seeking guidance from legal counsel, the auditor of the Office of the Chief Accountant. The Whistleblower Protection Act under the Sarbanes-Oxley Act mandates protection for whistleblower, stating that the employees and the contractors who report fraud and or testify about fraud to the Department of Labor are protected against retaliation, including dismissals and discrimination. Other key provisions and requirements under the Act include mandated disclosure in periodic report of transactions and relationships that are off balance sheet that could impact financial status. Near ubiquitous prohibition of personal loans from a corporation to executives. Establishment fines and terms of imprisonment for tampered or destroying documents in events of investigations or court action, and requirements for attorneys who represent public companies before the SEC to report security violation to the CEO.
Compliance costs are all expenses that a company uses up to adhere to government regulations. Compliance costs incorporate salaries of employees in compliance, time and funds spent on announcing new system necessitated to meet retention and so on. Compliance cost happens to be as a result of local, national, or even international regulation. For instance, MiFID II or GDPR applying to countries in European Union. Global firms operating all over the world with varying news regulations in each country tend to face significantly larger compliance costs than those functioning solely in one region. Example, people registered for value-added tax, shortly VAT, had to keep records for all tax, input and output, to simplify the completion of returns. They need to employ someone skilled in this domain, which is regarded as compliance cost. Compliance cost mostly includes the following: the cost to assemble and issue reports, cost of creating and maintenance of the system needed to collect facts and detail for compliance reporting, cost of persons to monitor compliance system and to construct them. Compliance costs are often combined and misunderstood with regulatory risk or conduct costs. Compliance costs are simply onward for following rules as they arise. It may include variance compliance, human resources policies, independent audits, quarterly reports, environmental assessment, etc.
Law that encourage ethical behavior. The first law, Security Act of 1933. This law is also called as Truth, security law. This law have two objectives. The first one requires investors receive financial and other significant information concerning security of public sale. Second, prohibit decent misrepresentations and other fraud in the sales of security. Second law, Security Exchange of Act of 1934. Same as the first law, it is also the response of market crash in 1929. This law serves to identify the prohibited conduct in market. Third law, Dodd-Frank Wall Street Reform and Consumer Protections Act of 2010. The goal of this act reshape U.S. regulation system in consumer protections, trading restrictions, credit rating regulations of financial project, corporate governance and disclosures, and transparency. Fourth law, the Sarbanes-Oxley Act of 2002. This act was created by Paul Sarbanes and Michael J. Oxley. This act put place in project to shareholder and public from accounting error and defectful behavior. This act has a 5 section. The first one, section 302, section 401, section 404, section 409, and the last section 802. Last act, the False Claim Act of 1986. The goal of this act was to give whistleblower from some of an incentive to bring fraudulent action of life. Therefore, all acts and laws have played significant roles of our country's business ethical standard that form standard that we have today.
Hello everyone! So today I will be sharing to you about the highly appropriate practices, and under this we have the cost-related marketing and the strategic philanthropy. The focus of core practices is on developing structurally sound organizational practices and structural integrity for financial and non-financial performance measure rather than on an individual's morals. Although the Sarbanes-Oxley Act and the Dodd-Frank Act provide standards for financial performance, but still, most ethical issues relate to non-financials, such as marketing, human resource management, and customer relations. Abusive behavior, lying, and conflict of interest are still three significant issues. Developing organizational systems and processes is a requirement of the regulatory environment, but organizations are given considerable freedom in developing ethics and compliance programs. Core practices do exist and can be identified in every industry. An important priority is for each firm to assess its legal and ethical risk areas and to develop structures to prevent, detect, and quickly correct any misconduct. Now let us consider McDonald's approach to answering critics about the nutritional guidance. The company began an initiative to provide nutritional information on its product packaging worldwide, becoming the first company to do so. McDonald's has been seeking to build trust and loyalty among their customers. They also offer new, healthier products such as oatmeal and pineapple slices in children's meals. Now let us go to cost-related marketing. Cost-related marketing ties an organization's products directly to a social concern through a marketing program. With cost-related marketing, a percentage of the product sales is usually donated to a cause that appeals to the target market. For example, let us have you plate. He generates proceeds for the Susan G. Comment for the Cure cause with its Save Leads to Save Lives program. Susan G. Comment for the Cure is a nonprofit organization that raises funds to help fight breast cancer. Cost-related marketing can also affect buying patterns. For such a campaign to be successful, consumers must sympathize with the cost, and the brand and cost must be perceived as a good fit, and consumers should be able to transfer their feelings about the cost to their brand perceptions and purchase intentions. Cost-related marketing has its weakness too, however. For instance, consumers may perceive a company's cost-related campaign as merely a publicity stunt, especially if they cannot understand the link between the campaign and the company's business practices. Also, these only last for a short period of time. And now, let us have the strategic philanthropy. Strategic philanthropy is the synergistic and mutually beneficial use of an organization's core competencies and resources to deal with key stakeholders so as to bring about organizational and societal benefits. It uses the profit motive but argues that philanthropy must have at least a long-term positive impact. For example, let us have the Gentle Giant Moving Company. It is a U.S. moving company which made it a priority to incorporate philanthropy and social responsibility into its business strategy. The company has established a charitable foundation that supports youth leadership development, housing assistance and homeless prevention, and the green initiatives to make its practices more eco-friendly. The company's successful integration of strategic philanthropy into its organizational practices has won it numerous awards.
The institutionalization of ethics is an important task for today's organizations. If they are to effectively counteract the increasingly frequent occurrences and blatantly unethical and often illegal behavior within large and often highly respected organizations, institutionalizing ethics may sound ponderous, but its meaning is straightforward. It means getting ethics formally and implicitly into daily business life. It means getting ethics into company policy information at the board and top management level and through a formal code. Getting ethics in all daily decision making and work practices down the line at all levels of employment. It means grafting a new branch on the corporate decision tree, a branch that reads right and wrong.
Greetings and good day, everyone. The important information and details has already been discussed by my fellow reporters, and my task is to bring to you the summary of the topic. The institutionalization of business ethics. There are three dimensions to effective business compliance. First is voluntary practices, core practices, and mandated boundaries. Voluntary practices includes beliefs, values, and voluntary contractual obligations of a business. Core practices, documented best practices often encouraged by legal and regulatory forces, trade associations. And mandated boundaries, externally imposed boundaries of conduct. Legal compliance, laws and regulations established by governments. Laws regulating businesses are required because stakeholders believe businesses cannot be trusted to do what is right in some areas. Political changes over time in response to business abuses and consumer demands for safety. Types of law, civil law and criminal law. Civil law defines the rights and duties of individuals and organizations. Criminal law prohibits specific actions and imposes punishment for breaking the law. Mandated requirements for legal compliance. Laws establish the basic ground rules for responsible business activities. 5 categories of law: regulating competition, protecting consumers, protecting equity and safety, protecting the environment, and incentives to encourage organizational compliance programs. Laws regulating competition. Laws passed to prevent the establishment of monopolies, inequitable pricing, and other practices that reduce or restrict competition among businesses. Laws protecting consumers. Laws protecting consumers require businesses to provide accurate information about products and services and to follow safety standards. The first consumer protection law was passed in 1906 in response to poor working conditions in factories. The FTC's Bureau of Consumer Protection protects consumers against unfair, deceptive, or fraudulent practices. The FDA regulates food safety, human drugs, and tobacco, and among other things. Groups with specific vulnerabilities have higher levels of legal protection. Laws promoting equity and safety. Laws promoting equity in the workplace protects the rights of minorities, women, older persons, and disabled persons. The examples of laws are Title 7 of the Civil Rights Act, then Equal Employment Opportunities Commission or EEOC, Affirmative Action Programs, the Equal Pay Act, and Occupational Safety and Health Administration or OSHA or OSHA. Laws protecting the environment, created in response to stakeholders' concerns about businesses' impact on environment. Sustainability, meeting the present needs without compromising future generation abilities to meet their own needs. Being a green company can boost profits. The Environmental Protection Agency, or EPA, was created to coordinate environmental agencies. Commonly, waste disposal is a serious problem for firms and individuals. Gatekeepers and stakeholders. Trust is the glue that holds businesses together. Gatekeepers, overseers of business actions, for example, the accountants, regulators, lawyers, financial rating firms, and auditors, are critical in providing accurate information to stakeholders. Accountants measure and disclose financial information to the public, assure accuracy. Some accountants have not adhered to their stakeholders' responsibilities, excessive focus on growth and profits, and conflicts of interest. Risk assessor, a group that failed in its duties to stakeholders during the most recent recession. Problems with risk model lead to inaccurate ratings and mislead investors and stakeholders. The Sarbanes-Oxley Act or SOX Act established a system of federal oversight of corporate accounting practices. Gives the Public Company Accounting Oversight Board or PCAOB authority to monitor accounting firms. Requires top managers to certify their firms' financial reports. Some legal protection for whistleblowers and loopholes existed and misconduct continued. And the Dodd-Frank Wall Street Reform and Consumer Protection Act, the most sweeping consumer protection legislation since the Great Depression, seeks to improve financial regulation, increase oversight, and prevent excessive risk-taking and deceptive practices. Created new offices: the Office of Financial Research, the Financial Stability Oversight Council, and the Consumer Financial Protection Bureau, and increased whistleblower protection, whistleblower bounty program, federal sentencing guidelines for organization, pass an incentive for organizations to develop and implement programs for ethical and legal compliance. Applies to all felonies and Class A misdemeanors committed by employees. Philosophy that legal violations can be prevented through organizational values and commitment to ethical conduct. Passed in 1991, amendments in 2004, 2008, and 2010. Highly appropriate core practices. Focus on developing sound organizational practices and structural integrity for performance measure, not a focus on individual morals. Most ethical issues relate to non-financial issues. The Sarbanes-Oxley Act and Dodd-Frank Act provide standards for financial performance. The Integrity Institute developed a model that standardized measure for non-financial performance. The voluntary responsibilities relate to business contribution to stakeholders. There are four major benefits: provide quality of life in communities, reduces government involvement, develops employee leadership skills, and helps create an ethical culture. Cost-related marketing ties an organization's products to a social concern through a marketing program. Strategic philanthropy, the synergistic and mutually beneficial use of a company's core competencies and resources to deal with social issues. And lastly, the importance of institutionalization in business ethics involves embedding values, norms, and artifacts in organizations, industries, and society. The failure to understand highly appropriate core practices provides the opportunities for unethical conduct. So it is very important to stay ethical in business. Thank you.